August 21st, 2025 will now come to order. I'll begin by calling the roll. Edgar Ono.
Here.
Warren Hartenstein.
Here.
Farhat Shah is not here. Chip Place.
Here.
Janice Chan.
Here.
Harry Miller is not here. Randy Craig.
Here.
And Chair Volney Ford is present. First, I want to welcome Randy to the Planning Commission.
Thanks for having me.
And we announced that a while back by email, but here he is,
Thanks for having me.
living proof that he exists.
Thank you.
Okay, tonight's Planning Commission meeting does not have any public cases. It is essentially a workshop, and which we've done many times in the past. And go ahead and distribute that. I'll just keep talking. In our workshop mode, we're strictly working on internal business, and of course, anytime we meet, the public is invited to attend and observe. But tonight we will not be taking public comment or anything like that because we're not making any final decisions tonight. So it's just an observation thing. Now, at the last month's meeting, we took the rules and procedures that we had worked up to date, and we took a hard look at a lot of recommendations that the city attorney made, to add to it and so forth, and we went back and forth, and I took all those notes from that last meeting and I incorporated them into a draft that I sent out to the commissioners, I guess about a week ago, a little less than a week ago. And I also took that opportunity to add several sections and to get into some areas that we did not have in the original, in the earlier documents, draft documents. And I sent that to you, and I also sent it to the city attorney, and she came back with even more recommendations based on that iteration. So when I sent out this draft version to you last week, in the email I indicated the changes that I'd made and the places and the paragraphs and the titles. Now, let's see what you're handing out here.
Same thing.
Okay, what Eric has just handed you is that same draft that I sent you last week by email with all of her recommendations in red. And then I just also tonight handed out to you a clean copy of what I sent you last week and incorporated her recommendations that you have before you right now. This can get a little confusing, but the best way I think for us to go through this is for you to have two documents in front of you. The first copy that's printed on one side only, and it's titled Amended Draft of 8/2025, because that's when I amended this yesterday. And that clean copy includes all the things that the city attorney has put into this document that was just handed out to you just now. That's printed on both sides, and it is in a finer print. So I think the way that we should go through this is to take the clean copy and put it right alongside what she just handed you. And that way you can look at this and tell which changes are hers, recommended changes. And if we do this just the same way we did it last month, if we just start at the beginning and go through and focus on the items in red, so let's start with
Mr. Chairman, is the 820 document different from what you, other than the city attorney's edits, is it different from what you sent out previously?
Via email?
Yes.
no. It's the same thing I sent out
A few
last
days
week
ago.
by email,
Okay,
and the only thing that's changed is her
I see.
her comments in red, her additions and corrections in red.
Okay. Do you mind if I sit up here, by the way?
Say again?
Do you mind if I sit up here?
I don't mind. You can sit right there if you'd like. Sure. I mean, this is a workshop.
Yeah, well. Thanks.
And by the way, tonight we're missing two, and you are acting as a regular member
Right, thank you.
and voting.
But we're not voting tonight, correct?
We're not. If somebody wants to vote on something, fine. We're not voting on this tonight. All right. I think it's going to be. I really do believe that we need one period to just absorb all this and make sure that the commission is happy with it, rather than trying to rush it into a vote tonight, unless somebody feels otherwise. So let's go to the section on elections. Now, if I get ahead of anybody from what we discussed last month, please stop me. Please correct me. Okay, if we go to the second page, elections, she recommended that we add the term "with all 8 commission members eligible to vote." When I had worked up the previous draft, I felt like that even though 8 commissioners can't vote on public business, that when we're electing our own leadership, I just personally felt that all 8 should be in on that. Now, if anybody feels differently, please let me know. 'Cause an alternate is a member of the commission, after all. They're just not a regular member, they're an alternate member.
Is there a pardon me, Mr. Chair. Is there a provision if there's a tie?
It goes into that, yeah, further down,
Oh, okay.
yeah. Down number 6,
Oh, all right.
yeah. Yeah, we got a pretty cool way of dealing with that.
I like it.
All right, anybody have a problem with all 8 voting, or does anybody feel like it should be 7?
No, I'm fine.
Fine.
Okay. Check by that. Okay, we go to the next page under meetings, and we go down to number 9. And this is just a formality of adding and the land use articles of the Maryland annotated code.
Volney, can I ask you a question about number 7 under elections?
Yeah.
It says all 7 regular members. Should that be 8, or is that fine the way it is with 7? I'm not quite sure why it's different from, the number 1.
Well, would an alternate be eligible to be an officer?
No,
So that's why 7 is 7.
you can't.
Okay.
There seems to be an internal conflict. We're saying all members shall vote, and then I think that's what Janice might be right.
Yeah.
And saying what now?
Well, and commission members shall be present. Nominees for hang on. I think it says at one point, all members of the commission shall be eligible to vote, and then
Yeah, but
That's just to vote in an election.
okay.
That's not voting on anything else.
okay. But then it says all regular members of the commission are eligible for. But in number 6, there seems to be inconsistent with
Number 6 where?
under elections.
That talks about a tie vote.
I think he means number 7. So I think I got the answer to that. So our 8th person is always going to be an alternate. So that's what you're saying.
Mhm.
The alternate cannot be running for an office. So
No, they can't.
that's an answer to my question.
Yeah. Okay, go to under meetings, number 9, and I just read that last little part in the land use articles of the Maryland annotated code. Anybody have a problem with including that?
Mr. Chairman, I had, if we're finished with number 9, I have a suggestion for number 10 to be added.
Okay, you would like to add number 10 under
Yes.
meetings?
Yes.
Okay, what
And
would it say?
It's something we discussed a bit previously. Number 10 would say, "The complete record of the meeting shall include the minutes, videotape of the meeting, and all documents submitted." Just so there's no confusion that the minutes constitute the entire record.
Chip, could you say that again?
Yeah, the complete record of the meeting shall include the minutes, videotape of the meeting, and all documents submitted. I have all this printed out, by the way. Not to add more paper to your pile, but if anybody wants this for the record.
Is that
Documents.
So that is a separate requirement that would be part of a public hearing anyway, but I would add the word archived video recording. Video, it's not a videotape, it's archived video, live stream video. Archived live stream video, that would be part of the record anyway. The problem we've had in the past is state law requires written minutes, and we were relying on, or the planning commission and the prior planning director were relying on the videotaped archives as the minutes. But there is a separate requirement under state law that minutes be written, showing the action taken. And under Robert's Rules of Order, it's just very minimal. It just says, this was the item on the agenda, this was a motion, this was seconded, this was the vote, the reason for the vote was X, Y, Z, and then the people would refer to the video for a more detailed version of what happened. But the minutes as written need to be a separate item, and that's what 9 was. So 10 would just be a reiteration of what is already being done, so it wouldn't hurt to put that in there.
so? Are you recommending that we put it in there, or?
I think you can add number 10 because I think it would apply in situations where you have a public hearing, where you have an application. You don't typically have,
Now, why would we create number 10? Why would we not just take number 9 and go deeper?
You could include it as part of number 9.
I mean, I think the
Yep.
point is well taken.
Yeah, yeah, you could do it either way. You could put it as a separate 10 or a separate item 10, or you can put it in with number 9. But either way, I would just refer to the videotapes as archived video live stream.
I would prefer it be included with 9.
Yeah,
I don't care.
because it's on that same topic, you know.
Okay,
it's-
whatever. Okay.
So if we, would you give me the words again that you would like to see added?
The complete record of the meeting shall include the minutes, the archived video live stream
Wait a minute.
of the meeting per city attorney, and all documents submitted.
Okay. Everybody okay with that?
Yep.
Yeah,
Okay, thank you.
good point. Okay. Now we get over to case application hearings. If you recall last month when we were meeting, we had this one big paragraph that kind of jammed a whole bunch of things together. And what I had done was I broke it out into several topics. No, I'm sorry, I'm not there yet. Case application hearings is all the city attorney did was just sharpen the language in that section. I'm getting ahead of myself. Okay, so it now reads public hearings that are held for the purpose of review and approval or of subdivision or site plans or other matters brought before the commission as a part of its powers and duties under City Code Section 2524 shall be conducted. And again, that language is to sharpen the language is really what it is. It really doesn't change anything that we had discussed before. So if you read number 1 in this latest draft that I provided to you, that's the way the city attorney and I are proposing that this now read under paragraph section 1. Does anybody have an issue with that? Problem with it? Okay, and then we go down to number 4. And city attorney just recommended that we strike the end of that sentence as essentially unnecessary. Trying to cut down on the words. Anybody have a problem with that?
Mr. Chairman. Hi, good evening. If I could just ask for a point of clarification on that, because it does say that the chair shall call upon the director of planning or his representative to present the application. I assume you also want us to present a staff report?
Now, which number are you on?
Number 4.
Okay. When you present the application, I think what we prefer is that rather than either one of you just taking the staff report that we already have and just sitting there and reading it to us, because we already have it, we're putting it in the record, that you basically mainly for the benefit of the public, that you summarize the staff report and hit its highlights. And that's what we've always done in the past. you know, rather than you going through the grueling process of just trying to read the whole staff report.
Mr. Chairman, may I add, I think that a summary would be, of the high points would be probably a good thing. I think recently we've been reading it verbatim into the record, so I don't think either one is more correct than the other. I think it's a matter of style because the document itself is part of the record. So that part of it, I think, would be up to the commission to decide which way they prefer. But I think one of the clarifications of the striking of the language was to allow the staff report to summarize the application, then allow the applicant to present their case, and then questions would go back to the director or the department for clarification, because really it's the applicant's burden to show that they've met the legal qualifications. It's not the director or department's burden to defend their staff report. And by questioning the director before the applicant even gets up to present their case, it seemed to be shifting the burden of what the planning commission is to be considering. So that is, from my legal perspective, that's why the questions of the director and the department would come later in the process, and it would focus on the applicant's presentation. And the initial statements by the director is just to summarize and present the highlights. But if they could read the whole thing in, but you're right, it is in writing, but the clarifications would come later after the presentation of the applicant.
In other words, we're not requiring the department to verbally enter the staff report at that point.
Well, it would be part of the record, but they're not there to defend it. The staff report
Right.
is what it is, and they can answer clarifications, obviously, but it's not their burden to convince the commission. It's the applicant's burden to convince the commission that they've met all aspects of the law.
Okay. Are you okay with that?
I'm just not clear if you, in this document, want to state staff report. It says application.
So maybe we could
So-
add language that says present
Department's findings.
the department's findings, and the staff report might be more accurate there.
Because I see application, I think that's just what the petitioner has submitted.
Right.
And so I just want to be clear that when we're presenting in the hearings that we're following the procedures. So do you want us just to present the application that they've submitted, or for us to present the staff report and our findings?
I personally would like to have all the information at one time, so that would be my thought. If you're going to present the application, you should also present the staff report. That's my thought. And I do have one question about that, though. If we don't have the complete thing read, isn't that kind of contradicting what we just said, that we need to have all three? We have to have we just added number 10, that last one. We said we needed the archived video, we needed the written, and if it's not read out, it's not going to be on the archived video. Do you see what I'm saying?
Yes, but and that's, because it's incorporated by reference. If you have the document in the record, it's duplicative if you also read it into the record. So that's why I said it could be done either way, because it's still in the record, whether it's in written form or orally stated. So to give an example, in a court hearing, if you have a deposition testimony being entered in as part of the record, there are some cases where you would read in the transcript into the record as if the person were there. There are other cases where you would submit it as an attachment, and it comes in as an attachment. So either way is correct. It's just a function of whether you want it as part of the verbal archived recording or not, and that would be up to the commission. And you could add that in here. But I think the clarification is the director is not presenting the application. They are presenting the findings and conclusions of the staff report, not the application. That's for the applicant to present.
Right. That needs to change.
So, does that answer your question?
Yeah.
So back to Jeff. What words would you, at this point after this discussion, what words would you prefer to add to the end of number 4?
I mean, it's really up to the commission. It's what do you want staff to do in the hearing? We're fine with presenting whatever you'd like us to present. We just need to know for sure.
Well,
I assume you want us to present the staff report and our findings to help you come to your conclusion.
Yes.
Then that would be satisfactory for us to proceed with that.
But what I'm hearing him saying is that we certainly should take out the word application.
Yes.
Change it to staff report.
How about maybe put in staff report or summary of staff report or something?
How about to present a summary of the staff report?
That's fine.
Does that sound good? You?
I think the public, should have the benefit of that too, in order to, have both sides of the coin here to make judgments on or
Yeah,
comments.
I think it's important for us to, educate the public that's attending and watching on TV and everything so that they get some idea what's going on here.
Right.
And I think that's the reason I've always appreciated the summarized version of the staff report. And it just basically introduces the case is what it does. Would those words suit everybody to present? Could we say a summarized version of the staff report or just say a summary of the staff report? Is that better?
Mm-hmm.
Okay.
And I would note that then further down on number 8, the chair may then invite members to ask questions and seek clarifications from the applicant or director of planning. So that gives the commissioners a chance to ask questions of the director of planning at that point.
Now, I was sitting here trying to write
Oh,
madly
sorry.
while you were talking. Good.
No, I'm just saying, for anybody who would be concerned that we don't have an opportunity to ask questions of the director, number 8 says, after the applicant has made his presentation, that the chair may then invite members to ask questions and seek clarification from the applicant or the director of planning in any order until the applicant has responded to all questions and members are satisfied with the responses.
So it's not in number 4.
Right,
down
it's in number 8.
as
Yeah,
it should.
so we basically skip a series of questions. And I agree that the applicant, it does have the burden and should be presenting sooner rather than later. And then we can ask questions of either the applicant or the director once
Well, see, one of the things that we have to be careful of here is that we can't have a huge amount of crosstalk going on. In other words, the chair has to basically keep order. And so if the public may have a question of the applicant, they may have a question of the department, they may have, and I want to make sure that the public's question, a person standing at the microphone trying to get some answers.
Well, number 8 is just referring to members of the commission asking questions. So
Oh,
this,
yeah.
Yes, but then we go to number 9 and we go to number 10.
right.
And that's where the public is.
Right, but we're not, I think the issue was that the city attorney was raising was that there's really no need to ask questions of the director until the applicant has presented his case. That being we as commissioners asking questions. So I'm just saying that we are covered under number 8 and that we can ask questions, we can still ask questions of the director, but after the applicant has made their case, instead of having 2 sets of questions.
Makes sense.
And then the public, has their chance to comment.
Well, I've always felt that that the questions that come before the case is presented are just questions about making sure that we understand something that was said in the staff report. It's strictly that. It has, you know, usually we don't have questions when the department, you know, makes their initial presentation. Oftentimes there's no necessity for questions. We don't have questions. But sometimes we do. We might have a question, or we didn't hear something clearly, or something, or we think that the verbal presentation might have somehow differed with what was written in the staff report, and we just weren't sure. So that's just to get a quick clarification before we move into the case. That's all. And it would just be an opportunity to do that. Yeah.
I did review some videos of other planning commissions, and the staff just presented what the staff report said, and it went right into the applicant's phase of the hearing. So while you can choose a different style, I think that because the burden is on the applicant, if you ask too many questions of the department before they get a chance, it might show prejudice, bias, telegraphing something. Let them present their case, and then you can ask questions. Oh, I hear you said this. Department, can you clarify what part of the staff report? Because Mr. Place was correct that in number 8, it gives you the opportunity to ask at that time. So it's just really a way to allow the applicant to have their day and present their case. I think sometimes what happens, or could happen, at least a few ones I've been at, is it could actually steer the applicant to answer things a certain way before they've had a chance on their own presentation.
So what you're recommending is I think is what's already written here, that we
Yes.
just,
That's what
I mean, it's good the way it's written.
Yeah, that would be my recommendation, but it is up to you. But I think to clarify the roles of everybody and who has the burden and how you're considering everything, it makes it easier to ask the staff report, ask questions from staff after the applicant has gone on. And then there could be some back and forth at that time as to whether certain standards or burdens were met or not met.
All right,
I think that would just be a more orderly process, but that's
think so,
just my legal
Everybody?
analysis.
And that's the
Good.
way it's written here,
yeah.
basically.
Yeah.
Everybody good with that?
Yeah.
All right. All right, we drop down to number 9. The chair shall then invite public questions and comments at a microphone which shall not require an oath. And what got struck out is that it shall not be considered testimony, because that was just kind of a redundant statement, but shall require the person's name and address and shall become part of the record.
Yeah,
And that was the important
Yeah,
thing
I
that
like
she was
that.
putting in here.
I like that.
Everybody good with number 9?
Yes.
Okay. And then we jump over, let's see, oops.
You know, I had a further suggestion that maybe I was going to insert at number 10, and we have discussed this previously, and it's regarding written submissions by the public. And I think it's still important for the public to be able to make written submissions. They've done that in the past, and especially when people can't be here. And I was going to suggest a clause that says, when members of the public cannot attend the hearing, written public comments must be submitted to the planning department no later than 9 a.m. the Wednesday before the Thursday evening planning commission meeting, downloaded into the planning commission shared drive and provided to the applicant. So that allows an opportunity for written comments to be submitted ahead of time and gives people an opportunity to review those comments ahead of time.
And where would you put this?
I put it at a new number 10 after number 9.
So you would put it between the current 9 and 10.
Yes.
And can you repeat the specific language that you're proposing?
Yes. When members of the public cannot attend the hearing, written public comments must be submitted to the planning department no later than 9 a.m. the Wednesday before the Thursday evening planning commission meeting, and that time can be whatever. Downloaded into the planning commission shared drive and provided to the applicant.
I would suggest it be made part of number 9, because that basically is inviting public questions and comments, and it's the difference is just whether it's in writing or in person. Correct.
Right.
Yeah.
Yeah, the point is to give people a chance to submit written comments if they can't be here, but submit them ahead of time so everybody has a chance to look at them.
I keep thinking about trials, and when a person is when a person's standing here in front of the microphone and they're stating information to the commission on the record, even though they're not under oath, but what they're saying is part of the record, correct? And we have an opportunity, if we so desire, to ask them a question or two, to interact with them, if need be. When somebody sends something in writing, we don't have a chance to do that. But then that becomes part of the record, but we have no opportunity to question it or clarify it or, qualify the statement or anything. And I personally feel very strongly that if a member of the public has something to say about a case that's before us, they need to be here. That's just my feeling.
Chairman, if I could add, it's not legally required or not, whether you accept public comment or not, but I would say minimally the things to look at. One is a staffing issue. I don't know if we have the staffing, if it's a contentious matter to get everything prepared and uploaded and all that right away might be challenging. But from a due process standpoint, I think a little more time would be needed if you are going to allow written comments, so that so the staff has time to get it to the applicant and the applicant has time to prepare a response at the hearing. So if you do accept the written comment, I think there needs to be a greater time period than 9 a.m. the day before. I think it should be usually 3 business days is standard, so maybe by Monday morning at 9 might be a little more doable. But I'm just concerned that if it's too late, then it starts pressing up against people's ability to prepare for the hearing. And I would hate to see things have to get postponed because there was a last-minute flurry of activity or something, after all the work everybody puts into it.
Yeah.
Has there always been a provision for written comments like this?
My understanding is there's never been a written rule on it, but that depending on the case, some have been accepted ahead of time, some were shared with the applicant ahead of time, some were not shared with the applicant ahead of time, so there was never any consistency historically. That's my understanding. But so if you do it, there should be a timetable and there should be some procedure of giving notice to the applicant, because they're the ones with the property interests that are before the Planning Commission that have a right to respond to any challenges to the plan they're prepared to present.
Now, what happens in the case, which can happen, if there's a major push to get a huge number of citizens to write in? I mean, the department is just flooded with all kinds of letters and this and that and the other. And they then obligated to process all that stuff and present it to us. And when they present it to us, do they have to read it into the record?
Well, and then the written comments are then handled differently than the in-person comments. In other words, the staff, the applicant has time to respond versus the in-person responses are, you know, you got to do it on the fly. So I don't know how you would deal with the fairness of that either.
Let me just add one other thing too. You know, with the testimony at the hearings, I think we have a 3-minute limit. And some issues might not lend themselves to 3 minutes and might be more technical an issue, and it would be, you know, it'd be more thorough exposition if you know, members of the public were able to write out something in greater detail without, you know.
You talking about city council meetings?
No.
No, I think here don't we?
We don't have a
3 minute?
limit.
We have yeah, we do. 3 minutes per speaker.
We do now, 3 minutes.
Yes.
When did that come about?
About 2 months ago, 3 months ago.
Didn't
Yeah.
realize.
Well, maybe that's something, I didn't see that in the rules, by the way, but maybe, you know, so it's, you know, some things can be technical. And, you know, maybe somebody can summarize it in a meeting, in oral testimony, but, you know, there's more behind their testimony than that. And so they should have an opportunity, one way or the other, to submit that. Ideally, they submit it, you know, far enough ahead so that all of us can review it before taking an action. I suppose they could submit it at the hearing, but then nobody really has a chance to study it or ponder it. So
No more than the other in-person people, though. In other words, the people who come to the public meeting. You know, there's no preparation to respond to them.
no, but that's true, Ed. But you know, it's again, I think something, you know, 3 minutes you have a chance to absorb it. But if somebody wants to submit, say, let's, for sake of argument, you know, an alternative traffic study or something, I don't think we'll see much of that. But you know, there should be a way to accommodate that.
Mr. Chairman, if I could add something. One of my concerns would be that written documentation can become quite onerous for the city staff, particularly if you have a citizen that like to just submit, say, a traffic study and some 100-page missive on their concerns, and then the staff has to compile that documentation. And so when they become responsible for maintaining, which could become a very voluminous written
That was my point.
concern, you know, written, you know, quantity here, then a page gets lost, then a testimony, then I think it could interfere with the record. So my thought would be, which has always been, is that city business is conducted here at City Hall. And if it's that important of an issue for you as your neighbors, then you come here to the hearing like everyone else does and state your case. And certainly it's the chair or the commissioner's prerogative if a citizen would like to submit some additional documentation to receive that documentation into the record or not, as the meeting or the issue determined is necessary. So that would be my concern. Maintaining, I mean, as you noted, you could get hundreds and hundreds of comments, and then the staff has to maintain all that as part of the record for that issue. And I think that could become, but I'll let the staff speak for themselves. My concern would be then a small innocuous mistake could taint the record and present unnecessary obstacles to the applicant or to the city.
I have a
Either way.
question regarding what you just were speaking about. If a person came to the meeting and they had documentation, are they authorized to hand it out to everybody, including the applicant? If they were to bring another traffic study in, are they allowed to come to the meeting and then hand us documentation that hasn't been given by the planning department? Is that authorized? Because that's, if they're able to submit it online, they should be able to submit it here. So I just need to know if that's allowed.
There's no legal requirement that I'm aware of that you allow written documentation or not of third parties. I guess they're free to, and you could restrict the manner in which that's done by your rules if you were going to allow the written submissions. Historically, people show up and testify at the hearings, and that's the information that you get, and you can have a back and forth about concerns over different aspects of a project. So if you allow the written, that just adds another element. And if people show up with something, that technically would become part of the record that evening. If somebody came up with, say, a 100-page additional traffic study, you could recess to have everybody has time to read it and digest it. You could adjourn to another night to have, to reconsider the additional information. So that would be a way to handle it if it was done on the night of.
Okay.
But that would be another option if you were to consider that.
My feeling is that if somebody comes in here with a technical document, you just mentioned a traffic study, for example, that would be something that that none of us would have had a chance to look at ahead of the meeting, and it would be something that the department had not had a chance to look at and verify and compare to, let's say, a different traffic study. And we would not even, could not even be assured of the validity of that document to be suddenly just laid on us right in the middle of a meeting. And
the applicant either.
huh?
Right.
Oh, the applicant, yeah. I mean, it would just be like something
It's a
coming at
hornet's
us out of left field, and I think that would be totally inappropriate. At some point, we've got to maintain order in this process. We can't just get absolutely, given the same treatment as an avalanche.
Well, could we make it that if there are written testimony that be just presented at the same time as the in-person testimony?
I personally don't have, just me talking, I don't have a problem if somebody can't make a meeting and their friend can make the meeting.
We've actually had that happen here.
Yeah, and that person standing there in that microphone, it's okay if they read something that somebody else wrote, but they're still presenting it live to us, and it's still on the video record, and it's a matter of the record of the case. But when stuff starts just floating in, that's much more of a problem, and certainly a huge problem for the department.
So my personal thought is that, Chip, that's a really great idea. I think that's it's fair to ask people to submit something online, but I just don't see how this can go cross the in-person, online, planning department. It just seems like it's much more of an octopus, that we might need to think about that one. I just don't know how. I don't feel comfortable doing both of them. I just feel like we need to explore this more, and we really need to talk to the people that would be getting all this information, which would be the planning department, getting these submissions. How would they feel about getting 100 submissions when they decide to build something on the hospital site? Or, you know what I mean? It's a bear.
Well, yeah, I think that's maybe a perfect example.
Yeah.
That's a perfect example,
I
it's a 3-minute, oral presentation at a commission meeting won't necessarily cover it. And it's not fair to the public.
Right.
To try to ask people to condense, comments on something very complicated like the hospital site into 3 minutes. And there might be, people might want to do visual studies that they present to us or other things. We have to find a way to accommodate that.
I think we could do that with special sessions. Like we did that during, when we did the comprehensive plan. We had our special sessions where we went through things and we hammered things out a lot during that time. But that wouldn't be during a typical session.
All right. Well, and keep in mind, or a workshop session or something,
Yeah.
but keep in mind, you know, usually these things are decided the same night. And, you know, some things are just too complicated to decide in one night. So I think we need to find a way to accommodate a little broader participation, especially written comments one way or the other, whether it's that night or in advance, so everybody has a chance to review them. Or we're prepared to, you know, if we receive something that night, we're prepared to table an action so we have a chance to fairly review.
That has always been.
Yeah.
If a member of the public has done a lot of research on something and they have a lengthy document to present to the process to make us aware of, it would seem to me that that document should first go straight to the planning department, and they should basically study it, absorb it, and make some administrative decisions about what's in that document
Authenticity.
and authenticate it and so forth. In other words, it's some of that stuff could easily rise above our level to grasp as citizen planners. In other words, we would not be qualified to dig into some of that stuff. That's my concern.
Well, that's why I suggested submitting it ahead of time.
So let's see if we can't come to something on this. Because we wrestled with this a month ago, the same issue, and we sort of just let it drop. And
Because it's a hard one to figure out.
the first question is, do we
Allow?
anything to be presented to the case, to the hearing, by a person who's not here? And that's the core thing.
Yeah.
We've done that in the past, where people have come in and spoke for others, even if they just read what the other person wanted to
Right.
submit, but,
Which I personally don't have a problem with.
No.
right.
Yeah.
Me
And that's always been, and it's the same rules for everybody, and everybody's treated the same. The rest, the other, public commenters, the applicant, the department, everybody gets that information as that evening. But what we're talking about allowing now is for someone to submit something in writing and there be, you know, additional deliberations about that before we even meet.
Chair, if I might add, you could always do a page limitation on written submissions. Courts do that all the time with the briefing submissions. You can only do so many pages or so many words or whatever. And using the time limit at the dais also for public comment period, you could do time limit that way too. So there are some things that could limit the burden if we're concerned about, you know, you want to have a complete record. It's clear you want to have a complete record, and you want to make sure public has access to have input. So those are the two key pieces: public access for the input, and then making sure the record's complete. So whichever way you decide to go, I just think looking at volume and staffing are obviously practical issues, but determining whether you want it to be before or night of, that's kind of a stylistic thing, but you can adopt page limit, time limit, things like that. How many days before you submit it, any of those features could keep it in a manner reasonable for this volunteer board to consider.
So in the planning department, if they were to have a form that would come to you and it would have like the box that you can have 300 words, just example, and they would have to have their name and address, so we have all the legalities on there. If that was something that you guys could, well, first of all, could you do it? And if you could do it, would you be able to handle the manning of who's going to handle that? And then would you be able to handle the manning of who's going to submit it to the applicant? Because these are the steps, correct? so far. And then we don't get to see that ahead of time because that's going to be presented at the meeting, correct? That would be how that would go? Because we
Yeah, so
shouldn't be
just a
seeing
few-
questions ahead of time. We should not be.
Yeah, so just a few concerns with that. If the commission does, accept these written comments, I would suggest that the applicant is the one that submits it to all parties, not to the department alone, and the department is the one that then disseminates it to everyone else.
Okay.
So I think that would be the best way to handle it. It's on the person submitting it to make sure that it's being submitted to the correct people. And then secondly, I don't think the department should be the one to present it during a hearing, because then we somewhat take ownership of the document, and then we have to study it, understand it, explain it, answer questions about it, and I don't think that's fair to the department to do that. I think it's public comment. The person, if you would like them to submit it, can submit it, but I don't think the department should be the one that has to manage that process.
Okay.
That's just my
So I don't expect you to answer that, but just suppose you were to get the form, okay? It would be sent back to be on your page, okay? And they would submit it to you, and I don't expect you to even read it, because really, why would you? It's going to be coming to the meeting, and
Right.
right. So if we have to submit it to the applicant ahead of time, which this is where my issue is, I don't think the applicant should even be getting it ahead of time, because they should be getting it at the same time the other people should, the people that are here. That's my thought. I just don't think it's fair. But if they did submit it, and then you were to, I'm thinking of the process here, so just bear with me. If they would submit it to you, you were to disseminate it to the board, the planning commission, if you felt like you needed to, or whatever the policy would end up being, that would be all that you would have to do. How would you feel about that? Just submit
we
the
could-
questionnaires to us. Like we could come in and you could have a pile of questionnaires for us. I'm trying to think of if there's even a logistical way of doing this. Am I making sense?
Well,
we could
I
talk
think
about
if,
the generics, but we
if
need
you would like us to, we could accept them. We could probably scan them all in. We could upload them to the website. We do with the staff report, so everyone can see it there. That may be the easiest, most efficient way to do it.
Yeah, Janice, all I suggested was if somebody wants to submit written comments, they submit them ahead of time, they submit them to the department drops them into the shared drive and forwards them on to the applicant. So that way,
We wouldn't-
these guys don't have to make any evaluation of it, or they just,
and have to read it.
they don't even, no, they don't have to read it. They just have to process it. So, but it's available to the commission, and maybe we can talk about this later, but maybe available to the public at large, like every other, application document that's in there.
I think it's, I have a really big problem with us being influenced by certain members of the public, attempted to be influenced on a case before the case starts. And if that stuff is dumped into a share drive, it could be letters from citizens, whatever, they in effect are getting a leg up on everybody else. They're getting to us before the case starts. And that's grossly unfair to the process. It seems to me the process needs to begin. The only thing we should ever get in advance is a staff report.
I agree. I think that if it's public testimony, it should all be delivered to all the parties at the same time, to be fair.
That's my point. Now, the way this could be accomplished is if somebody wants to submit something in writing ahead of time, it can be read into the record. Each one of those submissions can be read into the record right in the middle of this meeting.
By the chair.
But yeah, I could do it. I could get the vice chair here to do it. He needs something to do.
Well, it could take longer than 3 minutes, though.
Well, it doesn't matter. It's unfair to the process for certain citizens who choose not to come to the meeting to be able to attempt to influence the thinking of the Planning Commission before the hearing starts. And yet we've got all this other stuff in here that we're not supposed to be influenced by anyone before the hearing starts. You know, that's later on in these rules and procedures.
I think, Mr. Chair, if I may, I think you also can run into some concerns with authentication when you receive a large number of written testimony. If you're the chairperson that's happened to be reading it and it says so-and-so from this street and this address, and then they happen to call the planning department and they say, I never sent that in, that wasn't from me. There has to be some way to authenticate the testimony that's being provided, in my view. And one way to do that is it's here, and if it's someone else, they're doing the authentication. They're saying, I'm here for my neighbor, Mrs. So-and-so couldn't be here, she's ill, so I'm presenting her concerns. So they're the one authenticating the statement. If the chair or the planning department's reading it, then it becomes secondary and communication. So I think that would be a concern I would have about reading someone else's testimony into the record.
Yeah, I go back to my core belief that we should not hear anything that's not presented right here in this room in person.
Well, let me maybe move along on this. Maybe if people are concerned about submitting something in advance, let me just suggest that we entertain that if somebody comes at the hearing and wants to submit written at that time, then decide, well, this is something we need to look into further. They've raised points here. Maybe we need to table this until table the matter until everybody has a chance to review this. But I think we need to make some provision to allow written comments, written testimony that might extend beyond the 3-minute limit. How about that?
No, I think it's okay the way it is, and
To what? Okay to what?
our procedures and our rules are okay the way they are. I don't think we need to add another level of communication here. I think that in the past, people have always, if they had something that they wanted to introduce as testimony, that have found a way to do it, and I don't see what we could change to make that fair.
I agree. I think the commission always reserves the right, and if necessary, someone comes and presents, some document or photos. I've seen that a lot, past experience. One neighbor brings a photo, another one has a different photo. I think the chair and the commission always has the right and the opportunity, and city attorney, correct me if I'm wrong, to accept those documents with a vote. If there's, a quick vote, would like to accept the documents from Mrs. So-and-so into the record, the discussion can be had and they accept it. And then someone else will step forward and say, what about my paper? And then you could take it on a case-by-case basis as needed. So I don't think the fact that we don't have a procedure to receive written testimony or additional supplementary information doesn't mean it can't be accepted and put into the record as necessary.
And we've done that in the past.
So I don't think that just because it's not in here as a method, I think there is a method. You bring it here and the commission decides whether or not to receive that or not. That'd be my thoughts.
How do you feel about this?
I'm leaning one way, but I want one more question from the planning department. If citizens were to bring in their documentation of whatever, like Randy was just speaking about, to you like a week ahead of time or during the week sometime and drop it off, have they ever done that? Do they do that? Do they come in and say, look what would happen if you do this, or we know that you guys are working on this, or have you ever had that happen?
You're asking, has someone submitted comments prior to a meeting? Or?
Not comments, just they have something to argue with you about, or they want to give you some documentation about something that's wrong, like the sidewalk shouldn't be on this side, and you guys are saying that it should be, and we want to tell you why. Has anybody ever come in and talked to you like that about, or presented you anything like that?
I think Eric could probably speak to past practices here. I could speak to where I've worked before, but it may not be applicable.
That's really what I want to know. If
I have in
anybody-
previous jobs, but obviously I've only been here for a few months, so it hasn't happened since I've been here. But.
We're talking about a public hearing.
Yeah, that's what I'm talking about. If anybody was that interested to bring it in, they could have brought it into them before the meeting, is what I'm saying. Do we need to do this extra step when people already have the logical step of just bringing it in and presenting it to them at the planning department? That's what I'm saying. Why do we need to have an extra step if there's already if they can already come in and just drop stuff off with you for you to look at? Is that a possibility? I mean, why do we have to have a rule about how we run our meeting when there's availability if they have something to drop off with you?
Like, we would always meet with citizens or residents, and if they wanted to discuss a site plan with us, you know, we wouldn't say, sorry, we can't speak to you about this. So, I mean, I think that dialogue can occur.
Okay.
If I could add to, we've had situations at the city council level
Yeah.
where citizens who might be opposed to a particular project, rather than coming to this body, would come to the city council and use the citizen comment period to make comments. There was one project, infill project, where there was previously a dump site and there was concerns that it was a brown field, and the person came in with a binder and handed the binder out. So it didn't even get to the planning department level. It may have been discussed with one of the prior directors, but it never made it, to my understanding, I don't even know if that matter ever made it to planning commission. I think it was stopped before then for different reasons. But that's an example where citizens could bring it to a city council level, but it wouldn't necessarily trickle down to this level. I think the concern I have from a legal process standpoint is, what does the department do when it gets submissions if there's no rule for it?
Okay.
And that's the guidance, I think, that the
Thank you.
department needs.
That's exactly what I needed
Yeah.
to hear. Thank you.
Yeah.
Warren, I haven't gotten your take on this. What do you think we should leave it like it is, or?
I think to have spontaneous submissions by unrelated parties has had some confusion to the process, is probably unnecessary. I think if they want to be part of the process, then they should participate with the applicant to become part of the process before the commission. So,
Come in person.
yes.
And we'll go back to you.
We have a lot of other things to cover. I just, I'll kind of go along with Randy. If people come to a hearing and they have supplemental information that they would like to submit, I would hope that the commission would be open to receiving that supplemental information. And then on a case-by-case basis, the commission has the discretion to say, yeah, there's more to this than we thought. We need to take more time to evaluate
And
this.
that's the way we've operated.
I like that.
All right, if that's, I've just been concerned that, I brought this up because we had been receiving written comments, and they'd be on the dais when we got here, and then all of a sudden we stopped doing that. So I think we just need to be super clear one way or the other how this is working.
All right, so let's move on.
Good.
Where did I leave? Okay, we're down to number 13.
So I had one quick point on number 12.
Yes.
The middle sentence says, the motion shall receive a second, and members may vote to close the record or table the proceedings to give the applicant time to present additional evidence at a subsequent hearing. And I would have just added to give the applicant or city staff time to present additional evidence. Because it might be, city staff that.
Is that reasonable from a legal standpoint?
I think that's fine.
Okay,
Okay, thanks.
that's a good point. The applicant or city staff.
Because we can ask, under the state law, we can ask, staff to provide
right.
additional information if we
Okay.
request it.
Okay, function of the alternate member, we
were
cleaned
gonna
that
do
up.
13? That's changed?
Where's my 13? Oh, there we go.
Oh, thank you. Personal observations of a site visit is included now. That's good. All right, appreciate that addition in there.
That's good.
You're talking about the function of the alternate member.
No, I was back on 13. We're still under, the city attorney had made a edit there,
Yeah.
and the city.
I'm sorry, 13, that's right, we went back and I didn't
Yes,
finish with
right.
number 13.
Right.
Yeah, that was good.
So number 13, is everybody okay with the way 13 now reads?
Yeah.
Yes. Mm-hmm.
Okay. I'm sorry for getting ahead of myself. So then the next section was function of the alternate member, and I think that's pretty much the way we had it the last time. Everybody's good with that. Then we go to communication with others during pending case applications. This is where, when I sent out this revision to you several days ago, this is where I opened this thing up to basically three sections instead of just one section all jammed together. And I created the one section called communications with others during pending case applications. And that's essentially separates that from site visits. Site visits has strictly to do with how we do a site visit, how we conduct it, and so forth. And then the third section is our reliance upon professional expertise. And that last section has become a kind of a sticky point for us in the recent past. And so let's just start with communication with others during pending case applications. Now, I had written 4 things that got sent out to you several days ago, and all that was new to you from last month. And then our city attorney added a 5th item under that heading. Now let's just open up that paragraph, that whole section to discussion right now.
Yeah, I had a problem with this. And I appreciate the additional language that the city attorney added. I had drafted similar language myself, because there has to be a way for commissioners to say a site visit or reviewing the application to present that information. And I think it's helpful to present that information ahead of time. One, it just saves time in a hearing. 2, it gives the applicant and commissioners time to digest the information prior to a hearing. And, and then just writing it out is, I think, super helpful than trying to do it through some kind of cross-examination process. And I would have, I think I would have just deleted.
Essentially, this is meant to create a two-way communication between us as individuals and the planning department without trying to have a group email online and we're sitting here discussing the case.
And I don't think that's the best practice. Although, you know, reviewing open meetings laws like one-way traffic between commissioners is not prohibited. It's when people start talking back and forth that you run into trouble.
Right.
So, but I think a better practice is if a commissioner has reviewed the file and the application materials and has comments or observations and makes a site visit, has comments or observations, they should write that up and they should submit it to the planning department ahead of time so that the planning department can put that into the shared drive and provide it to the applicant so that they have opportunity to see that ahead of a hearing too. And I think that's the fair way of doing it.
Well, when you put something in the share drive, we all have access to it,
That's right. That's the point.
which is exactly what we don't want to happen.
No, I don't think that's a problem at all.
The public have access.
So if I could add, one of the things I was thinking about when I drafted this provision, and I'm by no means wedded to the language, but I'll use the example of the one entity that was before us, or before the Planning Commission, that had a recorded easement that wasn't even in the public record, and that could have been clarified ahead of time. And so instead, people were here for an hour, however long it was, and there was a lot of confusion because the record wasn't even complete. So that would be an example where, had the record been able to be made complete before the hearing, that time could have been eliminated and maybe rescheduled before we even got there. But that would be an example where I could see this procedure being used. Where I am concerned, though, is when you're stating your observations, are they in a manner of factual, see, hear, whatever, those kinds of things, versus my preconceived conclusions about those observations? And that's where it becomes prejudging the application. So I think that's where we have to be careful about our personal observations. Is we're looking at it, we're gathering information, it's in our heads, we can write down notes, but are we prejudging the applicant before they even get a chance to come before and present their case? And that's the delicate balance. I don't know how to express that in writing, but I think that was the distinction that was trying to be made by this provision.
To me, a simple question or a request for clarification coming from a commissioner is not an opinion, it's not a finding, it's none of those things. It's just that, you know what, there's something about the site plan I'm just not getting. I don't understand. Could you clarify that for me? And if the department looks at that site plan and says, you know what, that commissioner's right, that is a little
Wonky.
yeah, it's kind of hard to figure out. So I'll put out a communication to all the other commissioners saying that there was a question about this and I just want to clarify this. And that's it. And that's not influencing our thinking. It's not doing any of those things. But if we have a commissioner that comes and says, I went out to the site and I disagree with this, this, and this, and this, or, you know, that's a whole different ballgame. You know, we're just looking for questions and clarifications.
Just the facts.
And that's not going to happen very often. I mean, I can't think of too many times that I would ride by a site and then suddenly not be able to figure out what's going on. Or oftentimes, if I don't quite understand something, it's easy enough for me to get it clarified during the hearing, you know, if something's like that. But we've just got to go, to my way of thinking, we've got to go to the nth degree to prevent any type of bias going into these meetings. You know, the applicant, the burden's on us to be fair to the applicant, as fair as possible, because we are I mean, sitting here, we're the city of Havre Grace when it comes to these cases. And we're the face of the city. And we've got to be careful, got to be super careful. And
Can I ask somebody to clarify that, just read that out loud to me so that it makes sense? I've read it 3 times, and I feel like it's saying
It
to
was
me
written
that
by a
I'm not
lawyer.
allowed to ask any questions.
it was
of-
written by a lawyer. That's why I can't understand.
But I don't have a problem with lawyers. I just don't understand this particular question, because it seems like when I'm in a meeting, in one of our meetings, and something doesn't make sense, I'm not allowed to question the planning people until, how can I vote?
What?
Doesn't make, that's what I'm getting at.
Okay, so it could be part of the, it could be made part of the prior paragraph, because the prior paragraph 4 says, prior to a relevant case application hearing.
Okay, that would work.
So if you included it, it really is part of that paragraph and maybe shouldn't be a separate paragraph, because during the other rules that apply during the hearing, you have the opportunity to ask the
That's what I was
direct-
saying.
yes.
It kind of contradicted what we
Right.
just went through.
So this would be prior, this is communications with others during pending case application, so this would be subject to
I
that section.
agree.
So
Okay.
I think if you remove it as a separate paragraph, that might address
Okay.
the confusion.
Maybe we can do that then. That would help.
I would hope that as much clarification as possible, questions, et cetera, could happen in this room, so we all have the benefit of
Right.
hearing it,
Right. I agree.
Well,
rather than,
the point of this is, well, I see what you're saying. I mean, sometimes one of us might contact the department and we didn't understand something, but the minute they explain it to us,
Yeah,
sure, now we understand it. We
Yeah.
don't even need to send it out to everybody else.
right.
Everybody else probably already got it.
And Chairman, I would suggest that restating what the clarification was and the response to that be made part of the record also. But I think it helps the board, when they're hearing the cases, that if there are certain things that are glaring ahead of time, if you could be prepared ahead of time with the understanding, then it would make the hearing go more smoothly. And then you would state in the record, prior to the hearing, I had this request for clarification, and this was the department's response. And then you can ask the applicant, and do you have any comments as to that? Is that a correct interpretation of whatever? And so the record would be much more crisp and clear with that understanding, I believe.
I like that.
Yeah, I think that has been the intent of some written communications ahead of the hearing, is that, just in reviewing the application and visiting the sites, there were a number of questions. There were a number of issues readily apparent, and, there's, sometimes an attempt to get those out earlier rather than later. So both the department and the applicant and the commissioners have a chance to review those.
Okay,
So I like it if you add it to the prior number.
now what are you,
Just add that to the prior number 9, was it? Where am I looking at?
combine 4
Number
and
4.
5.
Number 4.
so you
Combine them.
would take 4 and 5 and just
Yeah,
combine
because
them?
it's the same thing. Because it's referring to the prior.
Okay, is that okay?
That's reasonable, yeah, based on the understanding of what
So
that's
just,
supposed
we'll
to
just
mean.
combine those?
Mhm.
Okay. Let me just make a note here. Okay, let's move to site visits. Let's look at number 1. Does anybody have any comments or concerns about the way number 1 is written and what it's trying to do?
Yeah, I have the same concerns I had before. I'm going to, again, read for you all what the state land use code says regarding site visits. In the performance of the Planning Commission's function, a Planning Commission and its members, officers, and employees may enter on any land and make examinations and surveys. That's it. That's pretty expressly written, and I don't think there's any need to really go beyond that. That's state law. And any rules that we make that limit that are, I think, are really inappropriate.
Chairman, if I may, I have reviewed some other cities, and they do encourage certain ways to do the site visits. This is not prohibitive, it's just suggestive. It doesn't in any way prohibit this, what the state law allows. And it's in recognition of tenants' rights on the properties, potentially dangerous topography issues that maybe the owner is aware of, that the members aren't aware of, and it just recognizes that. It would be horrible if somebody went to did a site visit, fell into a hole, and then has an injury. So I got my lawyer hat on when I'm looking at this, and people visiting property, even if they're legally allowed, they need to be aware if there's dangerous tenants or whatever. Tenants do have rights of possession, so one of the recent properties did have tenants on there at one point. I don't know if they're still there, but when we were out for a site visit by invitation to look at some of the barn property, the tenant was shocked that we were there and was very visually disturbed. So it was from that experience that I thought, well, we need to be careful. We don't want to invite any unwarranted misunderstandings of our board, which is a volunteer board, and owners and or tenants and or conditions on property. So it really is more protective. It's not prohibitive by its language.
Well, I also felt that even though state law allows us to go in with a heavy hand, and in other words, I've known ever since I first went on the commission that I could just, as long as it had something to do with planning commission business, I could walk on anybody's property, even on a neighbor's property, to look at a property that I couldn't see from the property itself, you know, and stuff like that. But I would never do that. And I mean, I think we as a small town commission need to observe some courtesies and some protective procedures and so forth, in spite of what the state law will allow us to do if we want to. And I think that's to your point.
Well, I agree. You know, if you have time, and if it's always a courtesy to let the landowner know if possible. Sometimes that's just not really practical. And, you know, sometimes you want to be able to go out there by yourself and take your time and examine the site thoroughly. So you know, and if there's a particular hazard or something on the site, or if there's tenants, that's good to know ahead of time. And, you know, that's something that, you know, we could be alerted to. But, for instance, under number 1, I think the first sentence is fine. You know, where practical, the site visit should be done from a public right-of-way without entering upon the relevant property unless it is currently open to the public. I don't think that's an appropriate sentence. I think we should be encouraged to go out and visit the site, and without, you know, that kind of limitation.
Well, what we've done here, we've used soft terms like where practical and should be done, and encourage and things like that. We're not mandating anything. We're not preventing a commissioner from going on the property. I'm thinking of a bunch of different cases that we've had in recent 2 or 3 years where there was absolutely no need to walk on that property. I mean, you could see the whole show right from the street. You know, what the heck did I need to go walking into the property for? Because it's, you know, I'm thinking of the Wawa site, for instance.
Sheets.
The sheets. And, you know, I don't need to walk into the property. I can learn everything I need to learn just by sitting there and not even getting out of the car. And a lot of the properties, commercial properties, are open to the public anyway, so the public can go on the property anytime they feel like it.
Well, I think that's your prerogative. Another commissioner might feel it's, you know, important to just actually enter the site.
We don't disallow you from doing that.
Well, there's no reason to put that sentence in there. It's really tends to discourage active participation
Yeah.
by a commissioner. So I'm opposed to that. And I'm also opposed in number 2, to secure written approval from the planning department, which will notify the applicant of each planned visit. Well, with all due respect to the planning department, we don't work for the planning department, and we don't need to seek the planning department's permission to enter on a property. It might be nice to notify the planning department if there's time. But, you know, we shouldn't be put in that position, because we have an absolute right to enter on property without anybody's permission.
I think there's an inherent public interest from the city's point of view, of which we're a part, some concern for safety and other considerations that I think April was suggesting, and therefore it warrants, you know, the communication, make sure the individual's visit is as absolutely protected as possible.
I think an applicant, a property owner, has every right to know when we're coming on that property, to be given the opportunity, a heads-up opportunity to know that we're coming on that property. Now, if the applicant says, I'm not going to allow the planning commission to come on my property, then we can invoke the state law and says, I'm sorry, sir, we are allowed by state law to come on the property. We're making a contact with you as a courtesy to let you know that we're coming on the property so that you don't shoot us, or you don't call the police because you don't know who the heck we are. You know, what are we doing out there? Why are we tromping around on your property? And that sort of thing. And all we're asking the department to do is to make the contact with the applicant, because
Well, you're asking the
remember, we're
department
not
to give
supposed to be
permission.
making contact with applicants. And they
If I
have
may
the
add-
applicant's phone number and everything. They know how to
If
get
I
a
may
hold of
add to that, so we get applications about 30 days, we put them on the docket, and then they get processed. Within that time frame, we send out public notifications 15 to 20 days in advance. On those notifications, they are sent to the property owners, the developers, applicants, attorneys, legal representatives, and adjacent property owners. I would maybe suggest that you can, at that time, put a line item in there that planning commissioners are subject to, you know, site visits on that per state law, and include that statement
Right.
on the notifications that are sent out to all parties.
Yeah, and in fact, the city code, under the site plan regulation, states that in submitting an application, the applicant is giving permission for commissioner's staff to enter on their property.
That is correct.
So there's really no need for further process here. They've already given their consent. The planning department certainly is not in a position to give approval to a commissioner to go out on site. And so it's covered in a number of ways. The applicant knows that they are subject to site inspections by the staff, by the way, and by the planning commission. There's no further need to articulate this further. The one I would agree with is the number 3, you know, to avoid inadvertently triggering a public meeting, that, you know, just we limit it to 3 people out on the site.
If I might add, Chairman, just going back to number 2 for a moment, if the board is inclined to change and soften the language, I would suggest that it states specifically that under the section of the city code and the section of the state's of the land use article, by submitting the application, the owner consents to the visits, but we ask that the owner submit to the Department of Planning any concerns over the existence of tenants or
That's good.
hazards on the property. And that way, the concern of injuries or misunderstandings would be alleviated. And then that we would have in the record that those things are present.
That puts the onus back on the applicant, and I like that.
Yeah, I
Yeah.
think that's good. That's fair.
And there's too little courtesy in this world anyway. I think the courtesy is probably a good thing.
No, I agree.
So if the chair would like, I could rewrite that with that language after this meeting's over. I don't think I could do that on the fly right now.
I still like the word encouraging versus will do, or
I'm sorry, can you say that again?
in your number 1, it
It'd be
says
number
commissioners are
one and
encouraged.
two, I think. 1 and 2, I think I'll combine those two.
Yeah, I really like the way that 1 is written, except for, as Chip was saying, number 2, the second part of that was not necessary. But anyway,
Yeah, and, I think it's important for commissioners and staff to be able to go out on the site, unchaperoned, by the way, and check out the site for themselves, and be free to do that.
okay.
Well, I certainly support the idea that we should be able to go as an individual out to a site if we want to, and that we should have access to the site as necessary to see all the things that we need to see. And
I like the way April phrased that, though, that on the form that the applicant has,
Right.
that's covered. I like that.
well, but why would we need to put in this rules and procedures that that's covered on a city
We
form?
don't need to,
We don't need to. It's just done.
yeah.
So is the thinking then that we should not require the planning department to get
Permission.
maybe approval is the wrong word, but to get maybe if we drop the written approval thing, but just that the department would notify the applicant that somebody's coming on his property. Is that necessary? I think it's not only courteous, I think it's probably the safest thing we could do.
Well, if I may, I think, again, if we have some sort of two-way street, and I don't know how that notification happens, I think one of the issues previously is while I noticed with one of the applicants, even though the commission members have the ability legally to go and visit the site, he was quite shaken to realize that 2 more visits occurred and he had no idea. There's no limit to the number of visits you can go that I'm aware of, but I think because he had been present at the prior one, it was somewhat troubling, so to him. And so legally, it wasn't a prohibition, but I think there's a two-way street, and then a lack of trust, there's a lack of trust that happens. So I think we need to clarify either in our application or in how we do the site. I think it should be publicly declared at a meeting. Oh, by the way, maybe the chair, oh, is anybody doing a site visit this week? Yes, I think I'm going to get out there. I'm not sure, I might get out. Like, I don't think it's wrong to have the public know that you're making the site visits, because quite frankly, what if nobody goes and does a site visit?
Right.
That's not good either. But, you don't have to get the exact date and time, but I think the public should know you're making the site visits and that you're doing your duties. So I don't think it should be a hidden thing. But at the same time, I don't think the law is not going to say you have to declare the date and time you're going. So I think maybe the communication on the application needs to be adjusted a little bit and cite specifically to the state law and the city code. And then maybe if the members can just contact the department to make sure that particular property doesn't have any issues with rabid dogs, tenants, hidden dangers, something like that. Is there anything they noted in the application? No, nothing. Okay, fine, then you can go. But you see what I'm saying? Like, it's just to really protect the integrity of the process, but also the safety and expectations of both sides.
So is there a consensus that we should
Is there, Mr. Chair,
soften up number 2?
if I may, just one moment, just before you move on. Is there a way that commission members identify themselves if they happen to be on the property? Do they have some sort of ID or some way to authenticate who they are to a property, if challenged or maybe if denied access? Is there any way to do that?
I don't know that they currently have anything, but maybe having some sort of identification would be helpful. I think that would be
I
something.
mean, I know as a state employee, as an inspector for a state, you know, I have an ID, a state ID, and it identifies who I am, so I say, here's who I
We got
am.
nothing.
So I'm just curious on how that process would work. I mean, I assume the owner would know they've had an application and to expect some visits, but they may not know who any of us
Seems
of
like
years
about, it was about,
Bonnie made up lanyards that have, I keep mine in the pocket of my car door, but, and it says, you know, it says a member of the planning commission and is entitled, so it's quite clear, identifies me, and it identifies my function.
it was about 5 or 10 years ago that the city made up these little things for us. And I think the lanyard is the best thing, because you can just put it around your neck, let it hang to here. And it just basically is a ID card.
Yeah.
It's in plastic.
And April, just to address your example there, there might also be an example where a landowner invites a planning commissioner out onto the site to give a tour of things that the landowner wants the commissioner to see. And then the commissioner goes out a second time, once the formal site plan application is presented, to be free to go and look at the site on their own without being chaperoned, and to take the time to study the site. So, you know, that can work a couple of ways.
It also gets you quickly through the gate at Bully Rock,
Yeah, believe,
you know.
well, that was a big issue.
Yeah,
Yeah.
you just hold it up and guy just opens the gate for you. That's right.
We had 3 projects in Bully Rock, and,
Right.
I mean, I happen to live there, so I could get to them, but,
Anybody needs to get to Bully Rock, let me know, I'll let you in.
Okay, let's go back to number 2, site visits. Question I have is, should we soften that language and not make the strong requirement that we have to get permission through the planning department?
Yeah, I think we should soften it.
Yeah, I think Eric's suggestion was, I don't think we need it, and I think Eric's suggestion and April's that basically the applicant is notified that, you know, people would be going out on the site, and it's up to the applicant to advise if there's any particular hazards or concerns before staff or commissioners enter the site. I think it be handled that way. I don't think we should, you know, be seeking permission or anything else.
I think, not to speak to that point particularly, but I do particularly like, and I think well done and helpful, last sentence, which need to require that notification, communication be made to the record that a site visit was held.
Yeah.
Excuse me,
that's good.
I had my mic, that a site visit was held by a particular member. I think that's very important. I don't think site visits should be done, you know, if they are done, to be done secretly or,
Right.
and I think that should be public information. If a member of the commission had visited, they should show say and put that on the record.
I really think we owe it to the property owner
I do too, and the applicant and whoever else, and the public in
to let them
general.
know why, you know, that
Right,
they don't have to, I don't want them following me around.
Right.
But I think that they should know that we're coming on their property.
or that we've been, I think Randy was saying that we've been on the
Yeah,
property.
that
Yeah.
know that we're gonna do it.
Yeah, well, I think Randy said that we should be on the record that we've been on the property.
Yes, that's what
That's different.
I like both parts of it. I like to be able, I mean, I think courtesy is important. But I understand the necessary to sometimes walk unchaperoned too. I don't see there's any harm in notifying anybody. If we have the right, there's no reason they could say no, they can't. So, but I do think it's important that if a site visit was held, that it be so said on the record.
So is your recommendation that we let the number 2 stand?
I don't have any problem with the way it is, to be honest with you, but I mean, I'm not necessarily opposed to changes, but I do particularly like that sentence and would recommend that it says stay.
Ed, what's your
Seems to me there should be some condensation there of those 4 points that, and I would leave that up to someone besides myself to make it more concise and clear.
So you're recommending that we just basically word this a little better.
Yes.
How about on this side?
I'm kind of leaning with Ed on that, but I'm also leaning with Chip. I think we should, as little as possible needs to be said in that paragraph. But I think we should use the word encouraging us to notify the homeowner if possible. But that doesn't mean we have to ever notify them. I just don't like that line at all. I think encouraging us to notify the landowner or the tenant that we will be doing visits. But I also love what Randy was just saying and April said earlier, that during our meeting, we should be saying we're doing site visits and who was doing the site visits. I think it should be part of our record that we're doing it, so that everybody knows this is gonna be a matter of course. This is what we're gonna do.
It should become a more common practice
Right.
for us.
Right,
It should.
right. So that's my thought.
Okay. Chip, do you have anything else to add to what you've said already?
No, I think I've covered it. And then, yeah, I totally agree with Randy that we should make public that we visited the site
Yeah.
and then, present whatever findings we had.
Yeah.
And there should be the vehicle for doing that, the mechanism for doing that.
Okay.
Okay, folks, we're getting down towards the end.
Yeah.
Number 3.
That's fine.
We're solving the problem of Open Meetings Act just by saying we'll never be more than 3
Right.
going on a site,
That's fine.
okay?
Right.
And I doubt seriously, as I've said before, that any of us can get our schedules that closely tied together where even 3 of us can go on a site at the same time. Okay. Now we come to number 4, and that's the purpose of a site visit.
Well, I object to this provision too, because, it suggests that we're not out there to take data or measurements, but again, the state law expressly states staff, commissioners may enter upon any land and make examinations and surveys. That's the point of this. And it's not necessarily to refute anybody. It's just to go out there and, maybe there's stuff out there that wasn't disclosed previously, that people didn't see previously, that was missed previously, and, it's our job to go out in all this, to be independent fact finders and to make our own observations and measurements of this. So I see no reason for number 4 whatsoever. And it's a little defensive, by the way. It's not necessarily meant to rebut or anybody. It's just to, we do our own investigation.
Well, number 4 is a segue into the next section.
Right.
And it's basically going to a much greater effort to delineate what is our responsibility and what are the various professional responsibilities. We are simply not qualified to do most of that stuff. We just aren't. No citizen planning commission is qualified to do that. And that should not be our role. Our role should be to hear the testimony of those who are qualified. And that's it. Now, if we feel like we got to go out there and investigate the site to every possible extreme degree, to see if we can find where the professionals miss something, I mean, none of us are qualified to do that, and we're just stepping way over our boundary by doing that.
I disagree. I think that's our job, and that's expressly permitted under state law. And there's no reason to limit us. And by the way, the whole next section is really, I think, totally inappropriate too.
Is what?
Totally inappropriate. So I haven't looked at how April marked it up, but you know, we have an independent role here. The Planning Commission is independent. We are required to make independent judgments. We make independent investigations if need be. We certainly have every right to question whether it's staff or whether it's the applicant's representatives. We have every right to ask questions. That's why we're here. And that is definitely part of the process. And if we didn't do that, there's no reason for us to be in here. The planning department could exercise all the approvals, and there's no need for an independent citizens commission. So I couldn't disagree more with your, Mr. Chairman, your what you wrote, especially on reliance on professional expertise. But, you know, but number 4, you know, since we're still on site visits, I think that whole section's inappropriate. We should not be limiting ourselves to, you know, regarding technical data or anything else, you know, we do out on the site that's expressly permitted under state law.
My concern, I don't necessarily disagree. My concern would be is when you have site visits by multiple commissioners. Let's say they're just using a tape measure, and you get 3 different measurements. And then you have a 4th one that's provided by the planning department. That's where my concern comes in, because if you have 7 people or 8 people collecting data and measurements and so forth, it can become unreliable. And that's just a very simplistic, you know, way to say it. So I feel like there should be some sort of a method or a means here to, I don't know how to say necessarily limit, because I want to make sure every commissioner is informed. But certainly that kind of technical data has to have, you know, a source and a home. And I think it can become cumbersome and if there's multiple data points. That would just be, I don't know how the commission's handled that in the past, but I mean, I live on a job site every day. I can tell you, you know, I've measured the same thing 50 times before. You know, so that's just my thoughts.
I see our role as validating the facts through testimony before us, testimony from professionals, and not our responsibility to go out and personally validate technical data. We are not qualified to do that.
There's a wide gap in the skills among us to achieve, to achieve a directed, quote, technical investigation. So there's, certain skills levels I would have, otherwise, other parts I would not have, and it becomes presumptuous. In other words, the power exceeds the skill sometimes, and that's not a good thing in public service, in my opinion. So I like the way number 4 approaches it. So that's my personal opinion. I also think we need to have bathroom breaks in these meetings. I'd like to be excused from the dais for.
Okay.
Yes, sir.
So I have a question. If we go on a site visit and we find something that we find disturbing or concerning or wrong from what we've read previously, shouldn't we be able to send that message and information to the planning department? Go ahead, April.
It would be my recommendation that if you go on site and something is not consistent with what the documentation you're reviewing, that would be the question to ask the applicant when they're at the hearing.
Okay.
And as they're presenting their case, and they say, well, there's a road and it faces this way, and you say, excuse me, I see that it says that in your plan, but let me interrupt you for a moment. The road doesn't face that way, it faces the complete opposite. Can you explain that discrepancy in your plan?
Okay.
Because the idea is to not do a gotcha moment and say, well, I observed this, and this is how it's going to be, and I'm going to put this fact in the record. You're going to ask them, why is there a discrepancy? And let them explain it, because they have the burden of proof.
Right.
So it's them presenting the facts, and then based on your observation, that informs you on what questions to ask the applicant. And then if you're not satisfied with their answer, well, as to that element of the plan, you could say in your deliberations, I don't accept that there should be that much incongruence between what they submitted and what we're looking at. And that actually happened in the one case where there was that forest easement that nobody had. That was exactly the issue in that case. And so that was good questioning. That was very good questioning. So yeah, that's how it should be developed in the record, not that your observation is the absolute fact. It's why is it different than what you've submitted? Can you explain that? Or do you want to submit a modified? Because the goal isn't, that their job is to show they've proven that they've met the law. The Planning Commission's job is to make sure they have, but if not, there needs to be guidance on what they need to do to meet it. The second part of that, and this is where there's been a lot of grayness, and that is, under the city code, even though the Planning Commission, it's given its role by state law, the city code also explains what the body is to do. And under 25-24, the first thing it does is review all applications for amendments to the zoning code and the map and report the findings and recommendations to the city council. They also review site plans. They review subdivision plans under 173. They shall hear and decide matters upon which it is required to pass under city ordinances. And the last one, they shall have all powers and functions from time to time by Maryland land use. Now, I've been involved in cases before the Maryland Circuit Court in Harford County, Maryland Court of Appeals, and the Supreme Court of Maryland. And the cases keep coming down over and over again. City councils, city boards, and commissions only have the authority expressly delegated by state law or local law. If a power is not expressly granted, that means it doesn't have it. If that power is given to another body, then another body can't do that power. So we've had circumstances where, for example, subdivision and site plans, it's a requirement that concurrently with those, forest stand delineations, forest conservation plans, and landscape plans are submitted to the Department of Planning for review and approval.
Right.
That's our law. So this body's job is to make sure they've been submitted and that this body is satisfied. If the commission is not satisfied with the Department of Planning's review of those plans, that's not part of the determination of whether the applicant's plan has met the standard, because our department approved it. Or, as it says in the law, if it's not approved within 45 days, it's deemed approved. And so if it's deemed approved 2 years ago, this body can't say, well, I think they have to submit a new one. There's no authority there. So that's part of the legal quagmire that I'm trying to rectify or clarify in terms of some of these rules is you need to act within the scope of review of 155 and 173. For example, I think traffic congestion is a big one. What's the impacts on a neighborhood of this increased development? So you look at it, but you can only look at a quarter mile. You can't look outside a quarter mile.
Oh.
So do you see what I'm saying? So there's overlap on what you can ask questions of and what you have enforcement authority over versus what you don't. I'm dealing with an appeal right now, and the question in that case was, does the Board of Appeals have the legal authority to put as a condition of their approval the payment of capital cost recovery fees. That's on appeal right now to the Maryland Court of Appeals. The circuit court said, I don't think they have that authority to put it on as a condition. It's already required in this part of your law, and Board of Appeals is a land use and zoning body. It doesn't have authority to decide capital cost recovery fees determined by city ordinance and DPW director. So that's something that's been convoluted over the past few years, and I'm trying to take that body of case law and try and superimpose it to make these proceedings consistent with the statutory and city code authority of this body. Is that helpful?
Yeah.
May I make a couple points here?
Yes, sir.
I'm going to Randy's point first. I understand that you could go out, a commissioner could go out on site and see something and measure something. And I'm not suggesting that the commissioner's measurement is determinative. I think the commissioner can raise this either, I think it's more helpful to raise it ahead of time so people are prepared, or they could raise it at a hearing, but you could raise the issue, and then, one would hope that the planning department would go back out and either confirm or verify that observation. And, if a planning commissioner goes out on the site and they happen to see, and by the way, forest stand delineation drawings, as an example, are required as part of a subdivision application. If a planning commissioner goes out on the site and says, wow, there looks like there's more specimen trees out here than the forest stand delineation drawing indicates, I think the commissioner has every right to bring that up. And then I think it falls back on the department to either confirm or verify that observation. And I think that's exactly the way that this should work. Because, some of these things, they can directly influence whether a subdivision is approved or not. If a road is proposed through a forest retention area where there's, no forest stand delineation drawing presented, but it's a road to access a subdivision, and there happens to be apparent specimen trees there, yet the applicant has an alternate way to access that subdivision through an existing road system, the Planning Commission could look at that situation and say, you know what, that this application should be accessed by the existing road system. It should not be accessed through an existing forest retention area. So it all goes hand in hand. You can't necessarily isolate one issue from the next. That's why traffic studies, that's why water adequacy, sewer adequacy, forest stand delineations, they're all part of the subdivision application. And the Planning Commission has to look at all of that. And if some of the base information is not adequate or is questionable, then a planning commissioner can and should raise those issues for further verification by the department. And so that's why I'm totally opposed to number 4, and I basically reject this reliance on ability to review this stuff. And it's not to jump on anybody or not to contradict anybody. And by the way, this is part of the normal design profession anyway. Design professionals are fully accustomed to this. They present something, you look at it, you say, well, something doesn't look right here, or something's, a little off there. I think you should go back and take a look at that. That's totally the way design professionals work. And I feel very comfortable working in that sphere. Other people may not.
So are you suggesting then that that we 7 or 8 commissioners or not doing our job if we don't go out in that field and do all those things?
No, I'm not saying that at all.
Well, do we anoint one to do that?
No, I'm not saying that either. I'm saying we all have individual skills that we bring to this. I'm trained as an architect, so I know how to do a few things. Other people, Warren has, really good economic background. If only you've done inspections yourself your whole life.
Well, I've developed subdivisions, and I have been a
So-
builder for a whole ton of years.
Yeah, well, there you go. So we all bring different
Randy, you're in
skills.
construction?
Yeah, we all
and-
bring different skills to bear. So,
But I don't feel qualified to do those things.
well, I think, and I think I'm not suggesting again that we are the determinative voice on any particular technical aspects. I think we certainly, though, have the right to raise issues if we see them and then refer them back to the planning department for, further confirmation. But we can't just ignore something that we see in the field and say, oh, that's not my job. That would be wrong.
My contention is it's not our job. So well, I guess that's the debate.
If I may read from the code again, under subdivision requirements, let's see what section is, 173-15, preliminary plans, review and approval procedure, subparagraph 4. If a forest stand delineation is required, the preliminary plan shall not be submitted to review to the Planning Commission until the forest stand delineation has been approved by the Department of Planning. The forest conservation plan shall be approved prior to recordation of the final plat. So if the Planning Commission's job is to make sure that the applicant has complied with the law, once they receive the approval from the department, that's your question. Did you receive approval? Were you satisfied with the plan? You can ask some questions about the plan, but you can't send it back and have them redo the plan because it's already been approved. That's a condition that they have met that condition of the law. Here's another one. If an analysis of water and sewage system is required, the analysis shall be completed and approved by the Department of Public Works prior to the submission of a preliminary plan. So that's another thing. The applicant checks the box. They got the Department of Public Works approval. You can ask questions as to how the Department of Public Works feels that adequate public facilities has been met. But you don't have the authority to send it back and say, we're not satisfied it has met adequate public facilities. You have to redo it because that's a Department of Public Works authority under the code.
Well,
You
April,
might disagree with how I read the code, but I can tell you when these things get appealed and I keep losing in the court because the court's telling me if you don't have authority, it's void ab initio, which means if you don't have authority and you approve something, it becomes void. It's as if it didn't happen. So that's why it's important for the body to understand the scope of its authority, because if you exceed the scope of your authority, then anything you approve is not valid. It's deemed not to have legal effect.
yeah,
So
but
I-
April, let me just on the adequate public facilities too. We've received, letters from the Department of Public Works that raise serious questions about adequate public facilities. They weren't necessarily determinative one way or the other. And, the water supply issue is a major issue in the city. And has it come out yet, that engineering study, Eric? It was going to be out in June and.
It's actually a water storage. We have enough
Right,
water supply.
storage, exactly, right. So, that's a case where a planning commission could look at that and say, this doesn't really sound like it totally answers the question. We would like to see that engineering report before we approve something. And that's exactly what state law provides for. If the body has additional questions, they could go back to city staff and ask for additional information. And it's the same thing with, forest stand delineation. If it might have been approved almost 5 years ago, but if you go out in the field and you see that this does not appear to be correct, then absolutely a commissioner can raise that question. And I think it's up to the department to go back and re-verify that what was determined almost 5 years ago is still correct, or if something might have been missed.
So I have a question regarding that as well. Again, regarding exactly what you're talking about, the water and the sewer system, and the fact that the Department of Public Works is saying, we have a plan, so it's approved. But they don't have the capability at the moment that we're trying to make a decision, but they're saying we have a plan. So I kind of have a wonder, is that an approval when they haven't really got it together to do it?
So our adequate public facilities ordinance allows either we have current capacity or current water storage or current transmission issues. There's multiple factors to it currently, or alternatively, the developer can fund the improvements, which is what we did with the Bully Rock parcel and in Lamson, I believe.
Yeah.
So they agree to fund the improvements. That's allowed under our law. So that funding mechanism is adequate public facilities.
And so that's an approval.
Yes.
Okay.
And also, if the city has in its budget plans to make the improvements that are going to be needed 2 years down the road, that is also under our law deemed to meet adequate public facilities.
And an approval.
Correct.
Okay.
And similarly with schools, my understanding is the way the schools work, which is really more the county's thing, but we have 110% of capacity under our law meets adequate public facilities, as long as we're under that.
Mm-hmm.
The school board, my understanding, is they won't even consider funding new schools until they're already overcrowded. So that's beyond the city's control. But our number is 110%, and so that's the number we look at.
Okay.
So there may be school overcrowding, you can hear testimony on that, but did they meet the standard they were supposed to meet? That's
Okay.
the question.
Thank you.
My position is, as a planning commission, we should look to the Department of Public Works and pose the simple question, is there adequate water for this particular project at this time? Can the city serve this project?
That's a good
Are you
question.
standing here and testifying, or is the department, our department, testifying that they have already communicated with the Department of Public Works, and for this particular project, the city can meet its service?
I think that's a fair question.
And that's all we need to know. We don't need to dip in deeper, because they are the experts more than any of us sitting here.
Right.
And that's who we rely upon for that information. And as a planning commission, we've got to rely upon experts for information and not question them from a technical standpoint, not take issue with their calculations or with their method of determining that. It's all we need to know is that it's we got the green light as far as water is concerned, or sewer, or whatever.
And
That's
I
just
might
my
add,
take.
there have been circumstances in the past where if the city did not believe there's adequate public facilities, it would say that in the staff report, and then they have to make the argument, the applicant would make the argument, no, I disagree with the staff report. We can meet it, and they may convince you or not, but the point is if the directors made the decision, it's because they've done the internal analysis of what that requires, both technically speaking and also as required under our city code.
Thank you.
Yeah. Well, I think we've seen examples where the department was ambiguous at best and said there really are not adequate public facilities. Good applications like sheets and all get hung up on that. But, there was a lot of hoops that would have to be jumped through before the department could, say there were adequate public facilities. And we have not had that. So that's why I raise these questions. I'd like to see more definitive answers from, say, the Department of Public Works that, yeah, the storage situation is solved, or there's at least a definitive plan to solve that, and it's going to be solved within the time frame that, the permit is still alive. And that's just not the case with sheets. It's not the case with Wawa. It's very, very ambiguous at this point. So, and it puts those applicants in a tough situation. But, I think those are the kind of things that a planning commission really should want to know. And, we often are not presented with that kind of definitive conclusion by the department.
I would say we seldom are, if you're talking about adequate public facilities, we seldom have insight into that issue.
I know, it's
on
important.
schools, I've chaired the county's redistricting committee. It's a job from hell, but
But that's basic criteria for approving a subdivision or site plan application, so.
well, you brought up forest retention area. I happen to have been the lead member of the outdoor caucus for DNR as that law evolved. And actually, it was a former Harford County Councilwoman who was the primary mover, Teresa. And but the observance and the violations that occur after the fact are pitiful, to tell you the truth.
I know. I've raised that issue right here in Havre de Grace. We see it all the time. Things just kind of happen, and proper waivers aren't granted for removing trees. That's why I am very vigilant about these things, because I haven't bothered to recite the things I've seen in Havre de Grace, but things aren't always run correctly. And so that's why I'm very vigilant, and I take my role very seriously, and I'll question everything. I think that's something because I've seen already, in just 2.5 years, things aren't always done the right way.
Mr. Chair, I would like to add, I think Chip, it's an interesting point here, but I just want to reflect back on what the role is here as far as fairness to the applicants. And I understand there's issues here and there and elsewhere, and sometimes things maybe haven't been done to your liking or someone else's liking or in accordance with the code. But I think you have to take each application as it comes with the applicant given it. You can't hold because somebody else didn't follow the forest delineation plan or didn't follow through on the FRA or one of those other things. And now we want to be, double and triple check and get another expert opinion in here or some other technical advice. I think that's kind of unfair to the applicant. They have the rules they have to follow from the code, which is laid out as Mrs. Zizek noted. And when the department says it's approved, it's approved. Now, I guess there's some questions that can go into that, but I think it would be really, really unfair to bring that kind of bias and a background to an applicant that otherwise meets the requirements. Be my thought on something along those lines. I hear what you're saying. I'm not saying that's not true. Mm-hmm. I just would like to take each application as it comes and not hold them responsible because 3 applications ago, the city department said they didn't have adequate water and sewer.
No, I agree. It should
how
be
I would
case
prefer
by
that
case.
the
Yeah.
planning commission review it,
And
and
I
not
think-
with that.
Right. No, I agree. And I think that's the way I've tried to approach it too. I'm not holding somebody responsible for what somebody else did 3 years ago, but I am holding the applicant responsible for what they're doing at that given moment.
Okay, we're going to need to think about wrapping up. Reliance upon professional expertise. That last section, that next to the last section, I'll just start around again. Do we leave it in, take it out? Start with you, Randy.
I like it. I think we leave it in.
Ed?
I'm not sure yet.
Now, we're not going to vote on this document tonight, so we've actually can think about this for quite a while.
You want another punitive session of 2 hours?
No, I think we're getting right down.
To be honest with you, especially as number 2, as the way the city attorney outlined it, it's fine that it's in there, but it seems almost unnecessary because the law is the law.
Yeah.
regardless of whether this is in the rules or not. The lost law, I don't know if you want to comment on that.
I agree with you that it doesn't need to be there because it's already what the law says.
Right.
Say again?
I said I agree it doesn't need to be there because that's what the law already says.
You mean number 2?
Yes.
Okay.
Well, in that case, I would say that if the law already says it, then there's no point in duplicating it.
The redundancy is unnecessary. I agree.
Okay. Janice, what's your take on that?
So here's my thing. We worked so hard on that comprehensive plan. I'm sorry to go back to that, but we worked so hard on that. And the responsibility we have to the city of Havre de Grace is huge, in my opinion, because we worked on that and we drafted that beautiful plan. And if we don't question when we think people have made mistakes, then we allow those mistakes to proliferate. And I don't think that's a good thing either. I think we should be able to question, like I just did with April, who gave me very good clarification on what the Department of Public Works says and does. If we can't question the authorities, then why are we here? Do you understand? We need
If
to
I
be-
may,
Go
you
ahead.
actually made a very good point. When you mentioned the comprehensive plan, one of the biggest things the Planning Commission does is to make sure what's being presented is consistent with the comprehensive plan. Because the comprehensive plan is one of the biggest things the Planning Commission does,
Yeah.
right? So you're going to look at the plan, is it in the right density? Is it in, are there connecting roadways? Are there, what are the other aspects? Does it have the sidewalks or whatever? Is there a park nearby? Like all those things in this comprehensive plan, that's a huge thing. That should be one of the first findings. We find that this applicant has met the requirements of the comprehensive plan.
I
and-
agree,
and
100%
blah, blah.
on
That should be number one on your list, because that's your main job, right?
It is
Make sure
mine.
it's compliant with the comprehensive plan. And then you go down the checklist. Have they met adequate public facilities? Based on the Director of Department of Public Works conclusions and based on our questioning of the applicant and the department, because you can question them, ask how did they get to their conclusions. If you find that the assumptions made are totally without basis, that might be a reason to question, but it has to be pretty severe. So I'll use an example. Before the hospital was closed, I met with some of the healthcare commissioners, with Delegate Johnson at the time, and I asked them, when you made the decision to close this hospital, vote in the dark of night in the middle of COVID in a Zoom meeting, did you consider how many people work in Havre de Grace or just who live in Havre de Grace? And they said, oh, we consider both. And my follow-up question was, did you count the people that work at APG, which is the largest employer in the county? And they both looked at me dumbfounded. No, they hadn't. Yeah, and they also, are you aware that Kirk Army Hospital is no longer a hospital, just a clinic? No, had no clue. And yet, they made a decision without full information. So to me, their decision was not even based on a complete set of facts. And that's an example that you can ask questions. What did you base your decision on? So that would be a key factor. So yeah, I'm not saying you can never question. It's the question should be based on how did you come to your conclusion? And then if the director can walk through, well, we have this issue on storage, but storage affects the fire flow rate, and the fire flow rate is required based on the fire standards, but if we can get certification that the on-site ability to put out a fire meets the capacity for that single facility on Route 40, that would meet adequate public facilities, because you've provided an alternative way to meet that standard. So that's an example of where it may on surface say, oh, we don't have enough storage. Well, what does that mean? That's a technical thing, but you can ask questions about that and find some comfort in the conclusion. So I think the way you ask the questions need to be based on, so what is the solution? Okay, am I satisfied that they met adequate public facilities, and did I ask the correct questions to make sure the assumptions and all the facts were considered?
So is there a way that you could possibly phrase all that you just said, which was very good, into this particular paragraph so that it doesn't seem black and white. You cannot ask the questions. Is there a way to phrase that if you find a major discrepancy, perhaps, you could maybe address that with whoever it may be or whatever? Is there a way to add that? Because obviously this is I think that's important that you have this, but I just don't like you cannot address it type of the way it comes across.
Right, I understand. I think we can work with some different language, but I think that's the nuance.
Right.
I think this provision is trying to get at. And I don't know what's the best way to say it, but
I think what we need to do is take that last section and polish the heck out of it.
Yeah, I think so.
And to be a little clearer about what we're trying to say and what we're trying not to say here. Because I definitely think that, of course, the Planning Commission has got a tremendous responsibility to get to the truth about the project, to get to the facts. But there's a big difference between challenging
I agree.
technical data and trying to do the job of somebody else that we're not qualified to do, and on the other hand, trying to get to the bottom of, in our opinion, did they accomplish what they needed to accomplish on behalf of the public?
I agree.
I think the exercise has been positive in the sense that I'll leave this process with an expanded sense of responsibility of things I can and should be doing. So that's it's not stated anywhere in that document. It's just the review of what we are doing is,
Responsibilities.
Okay.
Yeah, Volney, I'd say I think this has been a very helpful discussion.
Oh, yeah.
And I think it's important that we adopt some rules. I think we were making real progress when we got through like the function of alternate members, but the three sections that you introduced most recently, I think, I think they're a little reactive to maybe recent events. And secondly, I think, they raise more questions than they solve. I would suggest we focus on approving, up to the section with communications. We move to, solidify the stuff up to communications with others pending case applications, and then keep the other stuff for future discussion.
Well, with the commission's consent, what I'd like to do is conclude the work that we've been doing tonight and take the changes that we have proposed, the changes to this 8/2025 draft, and go back and approve that, and meet again in 30 days, our next meeting next month, the September meeting, and perhaps we can take this whole thing to a conclusion and vote on it at that time.
Sounds good.
Sound good to everybody?
sound good. Do you need a motion to support the work to date?
This is a workshop. I don't think we really need a
Okay,
motion,
just offer it.
because we're not really voting on anything tonight. We're not voting on.
As a new member, I would say that this is very helpful for me to begin at this time. You guys have already done the, you guys have already done the hard work. I just get to add a comma or two.
An hour ago.
Yeah, right. But I do really appreciate the work that went into this by the team and the information that informed it also. I'm sure it was hard-earned experience
Well, we've
to
been
put this
messing with
document
this
together.
here. Yeah.
April,
Okay.
thank you for all your work.
So, I think no further workshop business.
To be continued.
Huh?
To be
Do
continued.
I hear a motion that we adjourn the meeting?
I motion that we adjourn.
Just before we do adjourn,
Yes.
did we approve the minutes from July 17th?
Oh, we have not.
No, we haven't even seen them.
Oh,
No, Eric sent them out.
they were on the,
It was on the agenda for tonight, so I wasn't sure if you guys wanted to take that up tonight or wait till next time.
I mean, did you all send us minutes? That,
they were on the Google Drive.
Yes, they were.
what?
They were on the
Have to be a
Google Drive.
formal meeting, not a workshop. Just hold it until.
Yeah, we'll just have to hold it the next meeting. Yeah, if something's just sitting out there on Google Drive, it's going right over my head.
If I could add.
Half
for-
of us, we don't, it has to be sent to us.
If I could add for the record, you can approve minutes via email as long as there's no discussion about changes to the minutes from a policy perspective or other than maybe you're missing a word here and there. So you can actually, under Open Meetings Act, approve the minutes via email. So when you review them, if you just want to send an email back to the planning department, that would be adequate. But they should be done in open meeting, but you're allowed to do them by email as long as you're not,
Okay.
Commenting on them.
That was from our workshop on what was the workshop on what process meeting?
Oh, just the approval of minutes, that's all.
Right, but that was in that workshop that we could,
Yeah,
that was
yes,
the-
it was.
They were good minutes, by the way, Jeff.
All right,
Yeah.
motion to adjourn.
Thanks for your help, April.
You move, who seconds?
I second.